First and foremost, the Section 3 of the 14th Amendment
I would assume it would just be self-executing. It's in the Constitution. Why do you have to pass legislation upholding what the Constitution already says?
It is self-executing and self-evident. Indeed, it's obvious to anybody with a third-grade understanding of the English language. It says, take an oath to support and defend the Constitution, engage in insurrection or give aid and comfort thereto. You may not hold office. You cannot hold office unless Congress votes to remove the disqualification. The Supreme Court made up, out of whole cloth and contrary to Section 3's express language, the very text of the Constitution, made up that Congress has to pass some legislation further laying all of this stuff out. Here is the main problem with that ruling from the Supreme Court. One, it's actually not a ruling. It is something we call dicta. Dicta is non-binding ramblings and ruminations of Supreme Court justices. Why do I say it's dicta and it's not the ruling? Because, first of all, there is a bedrock principle in the practice of law, and the Supreme Court, among others, repeatedly has said, we do not issue advisory opinions. We only saw the legal wood, the very issue that is presented to us to be decided. And only after we've identified the issue, we've told the two opposing parties to brief that issue, and we've held oral argument so both parties can be heard on that issue, do we, the Supreme Court, decide that precise issue. We will decide no more, because no other issues were briefed or argued, and any opinion we might offer would be merely an advisory opinion, and we're not in the business of offering advisory opinions. And yet, Brian, they tried to do just that by boxing Congress in and by disregarding the plain language of Section 3 of the 14th Amendment. Here's why I say Donald Trump has been declared an insurrectionist 3 times over, and then we're going to move on to what the next logical and legal step ought to be, including according to the two authors of this new Hill piece. First of all, we already talked about the Colorado courts declaring Donald Trump an insurrectionist, and the United States Supreme Court not disagreeing with it, not invalidating it, not knocking it down. So Donald Trump, as we sit here, remains an adjudicated insurrectionist. 2, remember Donald Trump's second impeachment? I know there were so many, we tend to lose track of all of the Donald Trump's impeachments. His second impeachment was on a single article. What was that article of impeachment? Incitement of insurrection. The House voted favorably and passed that article of impeachment by a vote of 232 to 197. So Congress found that he engaged in incitement of insurrection. Then it went over to the Senate for a trial, and a trial was held. Again, this is important, at which Donald Trump was represented by multiple lawyers. He had his say. He made his legal and factual arguments, and he lost. And you might say, well, wait a minute. He wasn't removed from office after the Senate trial. No, but he still lost. What was the vote by the Senate on whether or not Donald Trump engaged in incitement of insurrection and should be removed? 57 guilty,
43.
57 guilty, 43 not guilty. In a very real and visceral sense, Donald Trump was found guilty by a bipartisan vote of the United States senators. 57 found him guilty of incitement of insurrection and said he should be removed, and 43 said no, he shouldn't be removed. Now, they didn't get to the requisite 67 votes to remove him, but make no mistake about it, by a healthy majority, they found him guilty of incitement of insurrection. That's the second thing we can point to show that, in fact, Congress announced that he was guilty of incitement of insurrection. The third is a little bit less firm, but I'm going to throw it in the mix anyway. It's the January 6th House Select Committee that presented evidence that we saw with our own damn eyes. And, anybody who took a realistic view of that evidence that was presented in the J6 public hearings, concluded, as did the committee, that Donald Trump engaged in insurrection. So what happens moving forward? Because we still have the Supreme Court issuing this advisory opinion that, well, we really need some congressional legislation. This is what it boils down to in the article, and I hope our viewers are sticking with us because that was a very long run-up to, I think, a more direct answer to the question. The article says the Electoral Count Act, which we all know will come into play on January 6th at the certification of the Electoral College votes. The Electoral Count Act says there are two reasons that, starting in the House of Representatives, which has the responsibility of certifying the vote, there are two reasons that members of Congress can actually vote against certifying the electoral votes. And here's how it reads, very briefly. The Act, the Electoral Count Act, specifies two grounds for objection to an electoral vote. One, if the electors from a state were not lawfully certified. We saw that happen the last go round, but that doesn't seem to be in play. But number two does. Two, or if the vote of one or more electors was not, quote, regularly given. And the authors of the article say a vote for a candidate disqualified by the Constitution, courtesy of the 14th Amendment, is plainly in accordance with the normal use of the words not regularly given. So they go on to make the argument, and I think it is not just a plausible argument, but a fairly compelling argument, that members of the House cannot vote for somebody, vote to certify the electoral votes that are being cast for someone who engaged in insurrection and is therefore disqualified by operation of Section 3 of the 14th Amendment, congressional legislation or no congressional legislation. That is the argument that they lay out, and I think it is, as I say, a compelling argument, but I know we're going to move on, Brian, and I want to give you a chance to pose the next question as to whether we think it's a winning argument.
Correct. And so now we have the virtues of the argument that the authors made here, but then I want to come back into what I think practically speaking is going to happen. And I think you and I, and probably most people watching, can agree that what will happen is different than what should happen. But what will happen is there won't be this big uprising from members of Congress. And so what do you say to folks who say, who a lot of whom are watching this video right now and saying, you've laid out at least 3 examples of why this certification process shouldn't move forward. And so how do you swear, given the black and white plain text of the Constitution, that Donald Trump will be able to take the oath of office anyway?
You know, you would have to conclude that the ruminations, the thought experiment, or more precisely what we call dicta, the non-binding things that Supreme Court justices say in an opinion, in a ruling, they should win the day. We should view those as sort of squarely addressing all issues concerning whether an insurrectionist can be sworn in, and we should just accept the Supreme Court issuing that dicta, that thought experiment, those ruminations about how, well, if Congress didn't pass a law, then the automatic disqualification of the 14th Amendment somehow evaporates. Somehow we ignore the expressed language of the 14th Amendment, Section 3, because gosh darn it, Congress just didn't do its job and pass implementing legislation. So if members of Congress who are sitting there wondering if they should affirm electoral college votes for Donald Trump, address this question sort of honestly and intellectually, they could certainly say, I believe this is a matter for Congress, and I'm going to exercise my independent judgment, and I'm going to say I am not permitted by my oath of office to certify electoral votes for an insurrectionist, even though I absolutely acknowledge the Supreme Court dicta, the ruminations, the thought experiment, because that wasn't the issue to be resolved in the case that was decided by the Supreme Court regarding the